Setting up your meeting for YouTube Live. Let's wait a bit. It's done, right?
Yes, it's live now.
Okay, okay. Okay. I'm putting you back as a host, okay?
Sir David.
Okay, sir.
Yes.
Recording ko katingal day ulang ti don chon. Ano me keu kan we.
Rampu, shall I record it from here also?
Yes, I think it will be better.
Okay. I'll just reclaim that thing again. Okay. Okay. Everything is running fine, smooth, right?
Yes, yes.
Okay. Okay.
I have posted the YouTube live link in the chat box.
Okay. Yeah, dear friends, for those who want to view the program live, the YouTube link has been posted in the chat box. You may refer to your friends for their convenience also. I have put up some of the YouTube link. Pungam, I'll be sending you one of the link also. YouTube live link. Shall we start? Our former principal, Puti Thangchomu, will be joining shortly. Okay, I think we can start the meeting. Okay, good evening, everyone. I welcome all of you to this international webinar on the topic, Amendment of the 6th Schedule to the Constitution of India. Well, I said good evening. However, for some, it may not be a good evening, it may be a good morning on the other side of the universe. Whatever, maybe good morning also from your side, especially the resource person camp is in the USA, so it's a morning on that side. So good morning. Welcome all of you again for this international webinar. We had a very unfortunate evening on the 21st due to some technical unprecedented problem. We were unable to proceed with the planned webinar. However, we are happy that we could reschedule the meeting on 23rd tonight, that even the resource person agreed to reschedule the meeting. And we are happy that we are able to conduct this live. For information that I would like to bring out to all the participants is that this program has been live. The link has been shared in the chat box, YouTube channel. This program is being live. We are using Rempuya Roku channel. So if there's anyone who is unable to log in using Zoom, they can view this program through this YouTube channel. And once again, I welcome all of you. Like I said in the previous night, this program has been awaited for a very long time. The thing is that we would like to organize such kind of seminar in a physical and offline mode. And we are planning, the IQSC and the Government Long Klai College is planning in future to have an offline seminar of this type, maybe 2 days or one week program to be held at Long Klai. And the resource person, Pungama, who is an expert in this field of 6th schedule, has already agreed to have a physical offline seminar. And thanks to him for his agreement. And we're looking forward to that. And those interested for such seminar, we will intimidate you through different media. Even if you would like to, we will update our program in future using the Long Klai Government College website. And once again, I welcome all of you. A special welcome to our resource person, Professor Jongkaman Dongel, who is now camped in the US from the University of Cincinnati, who is a senior professor of political science, Mizoram University, and also a senior fellow of the Fulbright. I welcome you. And I welcome all the participants, the organizing committees for this meeting. I hope we can have a fruitful meeting through the topic discussion. And we hope that this, even though it's the first webinar that has been organized by Government Long Klai College, we hope this won't be the last. This will be just the beginning. And we hope to have a better session in the coming years. At this moment, I would like to proceed with the program. I would invite our Vice Principal, Sir L.H. Moyet Nialum, to have an inaugural speech. Sir.
David.
Yes, sir.
I have one request. Those who are delivering speech or we have part in the program, please on your camera so that the participants also can see you.
Okay, okay. Yes, sir. Yes, the host, please make note of what the resource person said. Okay, sir. Silas Moya, please proceed.
Okay. Thank you, Mr. Simen. Respected principal, Mr. James Fortune, our renowned person, our renowned resource person, I mean, Mr. Professor J.W. and our coordinator, IQAC London College, Dr. David Vicente, members of the organizing committee, and esteemed participants. I'm honored to have the privilege of giving the inaugural speech on the first international webinar hosted by Government of College. And it is firstly important to highlight a little about the college which organized this webinar. And Government Long College was established in 1980. And currently we have 9 functioning academic departments. The topics of the webinar is quite relevant since let me continue. Since the college is situated inside a 6th schedule area, that is Long Klang, which is the headquarters of Lai Autonomous District Council, Mizoram. And it is also relevant due to the fact that it is one of the bonding topics, especially among the tribal population or the tribal areas of Northeast, because an amendment bill is going to be introduced in the coming winter session of Lok Sabha winter session, I mean, which is scheduled to be held in the fortnight of November 2021. And I'm quite sure that all of us may be aware of the fact that 6th schedule, Article 244 clause 1 and Article 275 clause, Article 244 clause 2 and Article 275 clause 1 to the Constitution of India was accepted by the Constituent Assembly on the 7th day of September 1949. And it allows the creation of autonomous district council in the tribal areas of Northeast India. And this autonomous district council is mainly aimed to safeguard the rights of tribal population, especially in the Northeast India. Autonomous district councils are bodies representing a district to which the Constitution has given varying degrees of autonomy within the state legislature. As of now, there are 10 territorial and autonomous district council. 10, I mean 1 territorial council and 9 autonomous district council. In Assam, Meghalaya, Tripura, and Mizoram. The rationale behind the creation of the ADCs is the belief that relationship to the land is the basis of tribal population. Tribal or indigenous population in Asia. The culture and identity of indigenous people can be preserved by ensuring the control of land and natural resources. And the basic, or to a large extent, define the lifestyle and culture of the indigenous people. As time passes, due to the changes on the condition and increase of population of the tribal people who are living in this Northeast India, certain amendments or changes has to be made. Certain changes in amendment Constitution of India, 6th schedule of the Constitution of India was made. And it still may be necessary because, as I have said, a bill is going to be laid down in the coming winter session of Lok Sabha. I will not go deep into details as we have the national expert committee. I think that it may not be exaggerating who is our resource person, Professor John Ramdonga, who happened to be one of the faculty of this Government Long Thai College, which organized the international webinar. And furthermore, it is my sincerest belief that many other things or ideas will arise during our interactive session, which will be held later in the webinar. That will be all for the inaugural speech. Thank you. Thank you.
Thank you, sir. Thank you for the inaugural speech. And now I'll hand over the program to Ms. Zarzo Zuale, who will be introducing the resource person and also moderating the session. Ms. Zarzo, please.
Okay, thank you, Sir David. Once again, a very warm welcome to all the participants. Before I hand over the time to our resource person, let me just give a brief introduction of Professor J. Dongdel. He is a professor in the Department of Political Science, Mizoram University, but at present, he is in America, University of Cincinnati, as a Fulbright Senior Fellow. He was once a faculty member in the Department of Political Science, Government Long Thai College, for which we still regard him as a family. During his time in Long Thai, due to his tireless efforts and intelligence, we were able to attain the first NAC accredited Grade B college outside Aizawl districts. His area of specialization is Autonomous District Council, 6th schedule to the Constitution of India, local government, and Northeast studies. That is why even the topic of our webinar is very, very relevant for the resource person. And as I've said in the previous night, we have the right man for the right job. And he has chaired technical sessions 27 times in international, national, and state level seminars and conferences. He has also published around 27 papers in all reputed journals, 25 papers in edited volumes, and 4 papers is still in proceedings. And he has also authored 4 books. He is a member of the Mizoram local government, that is the Panchayati Raj Drafting Committee to the government of Mizoram. And he's also a member of the Mizoram Boundary Committee. And with these few words, I will hand over the time to Professor J. Dongdel. Sir, over to you.
I hope I'm audible now.
Yes, you are.
Yeah.
Loud and
Okay. Thank you. At very outset, I would like to express my heartfelt thanks to the Almighty Father for enabling us to conduct this program today. And I'm also thankful to IQAC Government Long Trai College for organizing this program. And as already introduced by our moderator, I was in Government Long Trai College from 9 May 1998 up to 9 July 2012. And I still think myself as faculty and members of the college up till now. I don't regard myself as a stranger. I think it is my own college. And that's why I am ready to contribute and to do anything for the college even now. And so today, at the outset, I would like to request and remind my colleague in the college to strive hard and to work hard for re-accreditation of the college, because accreditation of the college has expired for almost more than 10 years now. And it is high time to put efforts together, to put our brains together, to struggle so that we will be able to get re-accreditation. And I hope that my colleagues in the college will try their best possible efforts to achieve the goal. And today I'm thankful that our founder principal is also on the line. He's fair available time to be with us. And I'm also thankful to him. And I'm thankful to all participants. Okay, let me go straight to the topic. And today, I will be deliberating on amendment of the sixth schedule. And one thing that I would like to express ahead of my lecture is that I am a professor specialized in autonomy and sixth schedule and authority of the subject. As professor with specialization on the topic and authority on the subject, I will be speaking the constitutional aspect. There may be many political issues, there may be many political slogans, and there may be many political propaganda. But I will be dealing with the constitutional aspect, what the constitution means, what is going on, and what will be done. So that will be the aspect of my lecture today. And the lecture will be divided into three parts. First, historical background of these tribal areas of Northeast India. And second part, incorporation of sixth schedule in the Constitution of India. Then in the third part, amendment of the sixth schedule. Sixth schedule has been amended 10 times now from inception of the Constitution till 2003. And after 2003, there is no more sixth schedule amendment. And one sixth schedule amendment will lapse in 2012, and one amendment bill, Constitution 125th Amendment 2019, it is still in the process. So I'll be touching all those from the historical perspective. Okay, let me start with the historical background. So what are the areas covered by this sixth schedule? So this sixth schedule cover particularly territories of the hill tribes. And the British East India Company, which started entering since 1600 AD, came so close to the boundary of Northeast India with the acquirement of Diwani or revenue of Bengal, Bihar, and Orissa by Robert Clive way back in 1765 from Mughal Emperor Shah Alam. And Robert Clive, he recognized Shah Alam as Emperor of India and recognized Shujah-ud Dawla as ruler of Oudh. But though there were emperors of India, and ruler of all, revenue was controlled by the East India Company. And this acquirement of the revenue by the East India Company gave chance to the company to come so close to tribal territories in eastern frontier of Bengal. And among those tribals, hill tribes, Garo tribe was the first hill tribe whom the British came into contact. And after contact with the Garo tribe, the British came to know that these hill tribes, they were different from plain Hindus and Muslims. They had their own custom, cultural tradition, traditional system of chieftainship, and they were totally different from the plain people. In such a way, these hill tribes in hill territories would not be able to be governed with the ongoing law and order which were prevalent in the plain area. And during that time, British East India Company got the opportunity to interfere in administration of a home kingdom because of Maumari rebellion. And due to rebellion of the Maumaris, the Ahom ruler Gaurinath, he invited the British to help him. Then the British East India Company sent force under Lumsden, and so kept those forces. They subdued the Maumari rebellion. Then it was kept under control. And during that time, the whole Northeast India was invaded by the Burmese. And as British had the aim to expand its empire in Northeast India, Burmese and the British were engaged in war, which was known as First Anglo-Burmese War, 1824 to 1826. And the Burmese were defeated in this war. The British forces moved as far as the capital of King of Awa, Lower Burma, which was Prom, and one treaty was signed on February 24, 1826, which was known as Treaty of Yandabo. And with the signing of this Treaty of Yandabo, Brahmaputra Valley was taken over by British East India Company. And with the signing of Treaty of Yandabo, tribal territories were annexed one after another. And Garo Hills was the first to be annexed before the signing of Treaty of Yandabo in 1822. And after that, Golpara was added to Assam in 1826. Kachar was annexed in 1832. Khasi Hills was annexed in 1835. North Kachar Hills in 1854. Naga Hills in 1866. Jantia Hills in 1883. Northeast Frontier Tract, present Arunachal Pradesh, was occupied since 1842, and annexation was completed in 1914. And Lusai Hills was occupied since 1890, and it was annexed to British Empire on 6 September 1895. In fact, there was no Assam province in pre-colonial period. The province of Assam was creation of the British for its own administrative. And after creation of the province of Assam, all these hill territories were annexed in the province of Assam. That's why hill territories in Northeast India, they were never part of a home kingdom. They were never part of any Hindu kingdom or Muslim kingdom of the plain. They had their own system of chieftainship. They were independent people in their own way. But after creation of this province of Assam, they were annexed in the province of Assam. But the British administrators felt that these hill territories, they were different. They had certain unique characteristics. So they could not be governed with the law and regulation which were enforced in the plain area. So exclusively for governing these hill territories, British enforced some regulations. So some of those regulations which the British enforced for governing these tribal territories in the hills of eastern frontier of Bengal or undivided Assam at that time were Regulation 10 of 1822, Garo Hills Act 1869, Bengal Eastern Frontier Regulation 1873, Scheduled District Act 1874, Chin Hills Regulation 1896, Government of India Act of 1919, and Government of India Act of 1935. So those were some of the exclusive laws and regulations which were specifically enforced for governing tribals in the hill territories. In such a way, since the colonial period, these tribal territories were governed with specific laws and they were governed with specific ordinances. Okay, then part 2, incorporation of the 6th schedule in the Constitution of India. So on the eve of India's independence, there was great fear psychosis in the mind of tribals in hill territories of Assam. How would be their condition after the British leave India? Would the British provided some type of administrative system or constitutional system where they would be able to govern themselves, or would they be so that they might be assimilated by the plain people? So the tribals were fearful of losing their land, autonomy, ethnic identity, language, traditional tribal practices, custom and culture. On the other hand, the British administrators were also quite concerned about future of the tribal people of Assam. And this time, prominent tribal leader from Khasi Hills and who was cabinet minister in the government of Assam and ordained minister in the Church of God, Reverend J.M. Nicholas Roy, he submitted them to a team of British cabinet mission. So as India was about to be independent, British government sent 3 British cabinet ministers, Sir Stafford Cripps, Patrick, and A.V. Alexander, to inquire about the situation in India, what type of institutional arrangements should be made so that power could be handed over to the Indians. And in this team, Sir Stafford Cripps was the team leader. So Reverend J.M. Nicholas Roy submitted memorandum to this cabinet mission inquiring about them. And he mentioned in the memorandum, we tribal were independent people. We were never part of plain administration. We were never part of Assam. But you Britishers, you came, you colonized us, and you demarcated us in the province of Assam. And now you will be leaving India. So will you provide some constitutional provision so that we may be able to protect ourselves from dominance of the plain? Or will you just leave us like this so that we would be assimilated and discriminated by the majority plain people? Then after that, the cabinet mission was also awakened about the status of the tribal. So before leaving for London, Sir Stafford Cripps, he called a press conference on 16 May 1946. And in this press conference, Sir Stafford Cripps, he made a strong suggestion. So he made strong suggestion to Constituent Assembly of India to set up advisory committee. That advisory committee should deal with the status of tribals of excluded area, fundamental rights, and rights of the minorities. And a strong instruction was issued by the advisory by the cabinet mission team. This advisory committee was appointed by the Constituent Assembly on 24 January 1947 with Sardar Vallabhbhai Patel, Iron Man of India, and the first Deputy Prime Minister of India as the chairman. But the coverage of this committee was so vast. It includes the present Northeast India, then mainland India, and even Pakistan, including Bangladesh and Pakistan. That's why the committee felt that it might not be able to do justice because it covers vast area. Due to that, the committee, advisory committee on 2nd February 1947 set up 5 subcommittees. Out of 5 subcommittees, which should deal with specific aspect, 3 subcommittees specifically deals with the tribal. So those 3 subcommittees were the one, Northeast Frontier Assam Tribal and Excluded Area Subcommittee under the chairmanship of Gopinath Bordoloi, which also came to be known as Bordoloi Subcommittee. Then Northwest Frontier Province, Baluchistan Tribal and Excluded Area Subcommittee, but this committee became defunct with the creation of Pakistan on 14 August 1947. And the third committee was Excluded and Partially Excluded Areas in Provinces Other than Assam Subcommittee, and A.V. Thakur was chairman of this subcommittee. And other than Gopinath Bordoloi, who was the chief minister, and in some book it was written as premier or prime minister of Assam. Other members of this Bordoloi subcommittee were Reverend J.M. Nichols Roy, Rupnath Brahma, A.V. Thakur, then Mayang Nokcha. And Mayang Nokcha was replaced by another Naga, Aliba Inti. But the Nagas did not properly participate in this subcommittee because the Nagas aimed for independence of Nagaland, and they did not fully participate and they did not fully support the 6th schedule provision. And in this subcommittee, they visited different hill districts. They came to Aizawl in April 1947. They went to Haflong, they went to Dipu, they went to Kama, and they could not visit Garo Hills and Jentia Hills, so they met Garo and Jentia representatives at Guwahati and Shillong. In such a way, the committee prepared its report. Then the committee submitted this report to the advisory committee. Then advisory committee then prepared and submitted it to the Constituent Assembly and the committee. So this draft was discussed for 5 heated days. On 5, 6, and 7 September 1949, and 16 and 19 November 1949. And after 5 long days of heated debate, the proposal was accepted. It was incorporated in 6th schedule of the Constitution. Then in Article 2442 and and 2751 of the Constitution of India. And in the original Constitution, this Article 2442 was incorporated as tribal areas of the state of Assam, because the whole northeastern India was known as Assam at that time. But now this Article 2442 states about application of 6th schedule in tribal areas of Assam, Meghalaya. The content of Article 2442 in 1950, it included only Assam, but now it's funding pattern. In Article 2751 from the consolidated Article 2751 clearly can go only through the state and it can government. And one thing that I would like to stress be a functioning of Americans in the United States of America. So Native Americans, tribal government. And one thing that I would like to mention is these tribal nation government the tribal in the 6th schedule provision, the state government cannot be bypassed. It is clearly mentioned in Article 2751. Everything should go through the state. So that is the difference between tribal nation government functioning here than the 6th schedule in India. Though the provision of 6th schedule has been copied from this functioning of the tribal nation government, this funding pattern, it is not copied. So that's I'd like to point it out. Then after 6th schedule has been incorporated, so all those tribal inhabited territory under this 5th schedule, they came to be known as scheduled area, and tribal inhabited territories under 6th schedule in paragraph 20 came to be known as tribal area. And having said that, paragraph 20 mentioned only tribal dominated area as tribal area. This is restricted only to 6th schedule. It is restricted only to 6th schedule language. In this regard, I was consulted by Accountant General Office, ISOL, because some constitutional question was there. Then I told them, this paragraph 20 of the 6th schedule, it is language of the 6th schedule, it is restricted to the 6th schedule. But this is not clear enough for definition of the tribal status, because some tribal areas may not be under 6th schedule provision. But if they are recognized as scheduled tribe under the order of President of India, they are also tribals, and their dominated area can still be tribal. That's why this paragraph 20 of the 6th schedule tribal area, it is specifically restricted to 6th schedule, and this very provision may not be appropriate for defining the status of the tribal. The status of the tribal may better be defined by presidential order of scheduled tribe list. So I advise the this AG office in that regard, because there was some question with regard to income tax issue. And in the original 6th schedule, tribal areas were listed into two groups. That is Part A and Part B. Part A means 6th schedule where the tribal were a bit developed and where self-government could be introduced, legislature could be introduced. So 6 tribal areas were listed in this 6th schedule: United Khasi Jantia Hills, Garo Hills, Lusai Hills, Naga Hills, North Kasar Hills, and Mikir Hills. So in this Part A, ADC, Autonomous District Council, could be established in all the 5 hill districts, but it could not be established in Naga Hills, because Nagas, under the initiative of Naga National Council led by Angami Zapu Fijo, fought for Nagaland independence, so they boycotted 6th schedule, and due to that, ADC could not be formed in Naga Hills. But in other 5 hill districts, ADC could function. Then there were 2 tribal areas where ADC could not be introduced. They were 6th schedule, but there was no ADC. That is Northeast Frontier Tract, present Arunachal Pradesh, and Naga tribal area. Naga tribal area was also known as Tuansang division. And this Naga tribal area and Northeast Frontier Tracts, they were totally backward at that time, and it was not fit for self-government. Because of that, they were under 6th schedule, but there was no ADC. And these Northeast Frontier Tracts and Naga tribal area was under direct rule of Governor of Assam, and it was being administered by Ministry of External Affairs. And from these Northeast Frontier Tracts, 5 administrative divisions were created. And those 5 administrative divisions were created by order of the President of India, Dr. Rajendra Prasad, in 1954. And Naga tribal area was added as the 6th administrative division, known as Tuansang Frontier Division. So the 6th Frontier Division of this Part B were Tirap Frontier Division, Siang Frontier Division, Lohit Frontier Division, Subansari Frontier Division, and these 6 frontier divisions were collectively known as Northeast Frontier Agency, NEFA. And the name NEFA became so popular afterwards. But this Naga tribal area, the slicing away of Naga territory and amalgamating with NEFA could not be accepted by both underground and overground Nagas. So they fought for re-amalgamation of this Tuansang Frontier Division with Naga Hills, which I will mention in the amendment process afterwards. And this Tuansang Frontier Division now form Eastern Nagaland. And from this Tuansang Frontier Division, now 5 administrative districts are created, like Tuansang, Mon, Kipiri, Longleng, and Noklak. And now we shall move on to the 6th Schedule Amendment, the third part. So the 6th Schedule originally contained 21 paragraphs. And as a result of many amendment process, many new paragraphs were added, like paragraph 3A, paragraph 3B, paragraph 12A, paragraph 12AA, 12B, 20A, 20B, and 20C have been added. But one thing that we have to know is that these new paragraphs were added. New paragraphs are added as subclause. So though about 8 new paragraphs were added as subclause, the number of paragraphs in the 6th Schedule is still 21. Likewise, with regard to articles of the Constitution of India also, originally Constitution of India contained 395 articles. And despite the addition of many new articles as a result of many amendments, the number of articles is still the same, 395. But if addition of these new articles, like in the form of subclause, are all counted together, now Constitution of India may contain around 477 articles. But constitutionally, in the Constitution, it is still 395. Likewise, even in this regard, with regard to the 6th Schedule also, the number of articles is still 21. But if all these addition of subclause paragraphs are added together, the 6th Schedule may now contain 29 paragraphs. So that is, the status how paragraph is maintained in the 6th Schedule. Then amendment of the 6th Schedule is mentioned in paragraph 21. So in paragraph 21, it is mentioned, quote, Parliament from time to time by law amend by way of addition, variation, or repeal any of the provision of this schedule, and when the schedule is so amended, any reference to this schedule in this constitution shall be construed as reference to such schedule as so amended. So 6th Schedule can be amended in 3 methods: addition, variation, or repeal. So those are the 3 methods of amending the 6th Schedule. It can be added, addition, some new provision can be added, variation means some provision can be changes, and repeal means some provision can be removed. So in these 3 methods, 6th Schedule have been amended 10 times now. And strictly speaking, this 6th Schedule can be amended by just simple majority, and it does not strictly conform to amendment of Article 368 of the Constitution of India. So from this provision of the 6th Schedule, we can know that 6th Schedule can be amended just by simple majority of the Parliament. But any legislature in India other than Parliament cannot change even one single word of the content of 6th Schedule. Only the Parliament has the authority. Okay, now we shall go after the amendment one after another. Up till now, as I've mentioned, 10 amendments have been made. And out of these 10 amendments, there was one amendment which was made without legislation of the parliament, and there was some controversy. And I will go after all those amendments in chronological order, one after another. Okay, the first amendment. The first amendment was Lusai Hills District Change of Name Act 1954, Act 18 of 1954. So this was the first amendment of the Sixth Schedule. Due to repeated demand for change of name of the Lusai Hills District into Mizo District, and due to repeated pressure from Mizo Union Party, so Parliament enacted amendment of the Sixth Schedule in 1954, which was known as Lusai Hills District Change of Name Act 1954. And this was a sentence of India, and it was published in Gazette of India Extraordinary in page 2. And after that, the name Lusai Hills District was changed into Mizo District. And in paragraph 20 of the Sixth Schedule, Lusai Hills Autonomous District Council was changed into Mizo District Council. And it was inserted after United Khasi Jantia Hills District. So in such a way, with this amendment, Lusai Hills District Council came to be known as Mizo District Council, and Lusai Hills District came to be known as Mizo District. And this was the first amendment of the Sixth Schedule. Then the second amendment was Naga Hills Tuansang Area Act 1957, which I mentioned a little bit earlier. As I've mentioned, the Nagas were so conscious about territory. So Nagas, both overground and underground leaders, could not accept sliding away of Naga territory and amalgamating with Nefa. So in this regard, the overground Nagas, they call a public conference called Naga People's Convention in 1957 at Kohima. And this was known as the first Naga People's Convention, or the first NPC. And this NPC was attended by 1,755 delegates from Naga Hills and Tuansang area, and 2,600 observers were from other Naga inhabited areas of Assam, Manipur, and Arunachal Pradesh. Then this first Naga People's Convention elected Imkong Lingba Ao as chairman and Josoki Angami as the secretary. And the convention passed many resolutions. Out of those many resolutions, one of the most important resolutions passed by the convention was re-amalgamation of Tuansang Division and Naga Hills into one administrative unit. As I've mentioned, Naga Hills was in Part A of the Sixth Schedule, and Tuansang Division was in Part B of the Sixth Schedule. So, and during that time, insurgent activities by the Naga National Council was so intensified. Government of India felt that it will be a good appeasement policy for the overground Nagas. So they gave good hearing to this demand of the first NPC. And in this regard, Parliament enacted the Sixth Schedule for the second time again, known as Naga Hills Tuansang Area Act 1957. And with the enactment of this Naga Hills Tuansang Area Act 1957 by the Parliament, Naga Hills was re-amalgamated again with Tuansang Division, and one new administrative division was formed known as Naga Hills Tuansang Area, NHTA. So as a result of this agreement with the NPC and enactment of the Parliament, Naga Hills and Tuansang area was re-amalgamated, and one new administrative unit, Naga Hills Tuansang area, was created on 1st December 1957, and it was listed in Part B of the Sixth Schedule. And this Naga Hills Tuansang area, NHTA, was placed under the administrative control of Ministry of External Affairs, and Governor of Assam governed the area as administrator, And from this Naga Hills Tuansang area, 3 new districts were created: Kohima district, Mokokchung district, and Tuansang district. In each district, there were deputy commissioner, and above the deputy commissioner, there was one commissioner who reported to the governor of Assam. And this NHTA, it was not exactly union territory, but it was created in UT-like structure. It also had a legislature. Then in this NHTA was given 1 member each in Lok Sabha and Rajya Sabha. And the first Lok Sabha member from this NHTA was S.C. Jamil, who was also inducted as Deputy Minister in charge of External Affairs in Nehru's cabinet. And in such a way, this demand of the first NPC was fulfilled. And the second NPC was called again at Ungma village in Mokokchung district from 21st to 23rd May 1958. And here, in this second NPC, 16 proposals were resolved by the second NPC. And out of these 16 proposals, the most important one was upgradation of this NHTA to state of Nagaland. Then they appointed one subcommittee to work on the modalities of those 16 proposals. And after that, the third NPC was convened at Mokokchung 22nd to 26 October 1959 after 1 year. And that third NPC accepted all those recommendations and work done by the second NPC, and they resolved to praise the government of India for creation of the state of Nagaland from this NHTA. And due to this repeated pressure, Prime Minister Pandit Jawaharlal Nehru announced in the Lok Sabha that state of Nagaland will be created, and process has been started. And due to that, Constitution 13 Amendment Bill was enacted by the Parliament, and as a result of that, state of Nagaland was created on 1st December 1963. And after that, NHTA was deleted from Part B of the 6th schedule. So that was the second 6th schedule amendment. And the third 6th schedule amendment was bifurcation of United Khasi Zentia Hills Autonomous District Council in 1964. And this was up till now the most controversial 6th schedule amendment, because this amendment was enforced without being legislated in Parliament. But this problem was solved by the Northeastern Area Reorganization Act 1971. How it happened? The United Khasi Zentia Hills District Council comprised of 2 hills, Khasi Hills and Zentia Hills. And this UKJHADC had 18 members, and 24 members. Out of 24 members, 18 members were from Khasi Hills and 6 members from Zentia Hills. And as Zentia members were less in number, they felt that they were marginalized. Lion's share was taken over by the Khasi Hills. So those 6 members from Zentia Hills, they submitted memorandum to Union Home Minister Govind Balapan on 1st November 1957 for creation of separate Zentia Hills Autonomous District Council. Then after that, another memorandum was submitted by MDC of these Zentia Hills to Prime Minister Nehru on 30 December 1957. Then Secretary of Zentia Darbar also submitted another memorandum to Governor of Assam on 8 July 1961, sorry. Then Government of Assam appointed one commission under Paragraph 14 of the 6th schedule to study about the demand of these Zentia Hills for creation of ADC. Then to this German commission, they visited the area, they met various representatives, and they received 43 memoranda from different Zentia civil society organizations, political parties, and political groupings. So on the basis of this German Commission report, Governor of Assam issued a notification on 23rd November 1964, which has been placed in Legislative Assembly of Assam, and as a result that which was placed in the Assam Legislative Assembly, a notification issued by the governor. Notification was issued for bifurcation of this United Khasi Jantia Hills District Council on 1st December 1964. And as a result of that, UKH ADC was bifurcated into Khasi Hills District Council and Jantia Hills District Council. But strictly speaking, this was not legislated by Parliament, and it was a bit unconstitutional. Due to that, Mr. Edwinson Barre filed case against Government of Assam in Supreme Court of India. And that case was one of the most popular cases. It was known as Edwinson Barre versus the state of Assam. Then, when the Supreme Court discussed the matter, majority judgment of the Supreme Court held the view that paragraph 1, subparagraph 3 of the Constitution of 6th Schedule to the Constitution of India gave power to the governor. So they justified the action of Governor of Assam and Government of Assam. But during that time, there was one very prominent dissenting view among judges of the Supreme Court, who was none other than Justice Muhammad Hidayatullah, who was later on the Vice President of India. So Justice Hidayatullah mentioned in his dissenting judgment that this creation of new ADC, it relates with list of tribal area in paragraph 20, so it could not be enforced and it could not be carried without Parliament amendment. That was the dissenting judgment given by Justice Hidayatullah. Then, but as majority judgment favor, it was not scrapped. So ADC was bifurcated. And constitutional debate was going on. And in the midst of that ongoing constitutional debate, when the Northeastern Area Reorganization Act 1970 enacted by the Parliament, one clause was added to solve this constitutional problem. And that clause was subparagraph 3 of paragraph 1. So in this subparagraph 3 of paragraph 1 of the 6th Schedule, which was added by Northeastern Area Reorganization Act 1971, it is that this subparagraph may contain such incidental and consequential provisions, including amendment of paragraph 20 and of item in parts of the table as may appear to the governor to be necessary for giving effects to the provision of the order, unquote. So this Northeastern Area Reorganization Act 1971, by adding in subparagraph 3 and paragraph 1, clearly mentions that as it is related with paragraph 20, it cannot be done by the governor without Parliament enactment. And after that, no more constitutional crisis was there. And this has been misquoted by some lawyers. I even have argument with some lawyers. They say that governor can create it and even Supreme Court approve it. Whatever the Supreme Court is the final authority, but in democracy, there are 3 organs of government: legislative, executive, and judiciary. So law is passed by legislature. What the law passed by legislature is adjudicated by the judiciary only. That's why it does not mean that the court can do everything. The court also follow the guidelines only. That's why any amendment or any change in wording of the 6th Schedule cannot be done without Parliament enactment. So this has been solved by Northeastern Area Reorganization Act 1971. Okay, we'll move on to the next amendment. Amendment 4. The Assam Reorganization Meghalaya Act 1969. So with the creation of Autonomous State of Meghalaya, Parliament enacted the 6th Schedule, that is the Assam Reorganization Meghalaya Act 1969. This is Act 55 of 1969. Then what changes has been incorporated by this amendment? As a result of this amendment, the number of seats in Autonomous District Council increased from 24 to 30. Then in the second amendment, in the list of state, earlier it was mentioned only Assam. Now it should be mentioned Assam and Meghalaya. Then in many paragraphs of the sixth schedule, like the word Assam has been changed into state. Then the tenure of member of district council has been clearly written as 5 years, but nominated member shall hold office during the pleasure of the president, the governor. So earlier, there was no specific mention of the term of nominated members. But in this amendment introduced in 1969, it is clearly mentioned that nominated members shall hold office during pleasure of the governor. Then one new paragraph 12A has been inserted for application of laws in Meghalaya. So this is the fourth amendment. Then the fifth amendment. So this fifth amendment, the Northeastern Area Reorganization Act 1971. This is Act number 81 of 1971. And this act is like 42nd Amendment of the Constitution of India. It is like a mini constitution because it touches many parts of the Constitution of India. And this act created 3 new states, Manipur, Meghalaya, and Tripura, and 2 new union territories, Mizoram and Arunachal Pradesh. And the act touches many parts of the Constitution of India. It is divided into 9 parts, and it is published in the Gazette of India on 6 January 1972. But we shall deal only with those parts which deal with 6th schedule. Only the specific area where it is concerned with 6th schedule, I shall briefly mention it. So, and one thing that I would like to add is that this Northeastern Area Reorganization Act is the Act of Parliament which officially created the term Northeast. Before, there is no official Northeast. The term Northeast has been used officially after the enactment of this Northeastern Area Reorganization Act 1971. And this Northeastern Area Reorganization Act causes change in many paragraphs of the 6th schedule. And earlier, wherever the word Assam was written, it should now be replaced with State of Meghalaya and Union Territory of Mizoram. Then one very important clause was added. Clause H was inserted after clause G in subparagraph 3, paragraph 1 of the 6th schedule. Then what is mentioned in that clause H after clause G in subparagraph 3 of paragraph 1, divide any autonomous region into 2 or more autonomous regions and define the boundaries thereof. So with the provision of this clause H, Phoi Lakhal Regional Council was trifurcated into 3 regional councils on 2nd April 1972, and they were subsequently added to Autonomous District Council on 29 April 1972. And this very clause gave power to Administrator of Mizoram to trifurcate PRRC, which led to creation of Chakma Autonomous District Council. So many questions and many say Chakma Autonomous District Council is not constitutional. What I'd like to mention is that the manner in which the Chakmas immigrated into Lusa Hills may be illegal or otherwise, but the manner how CADC has been created, it is as per this provision, so it cannot be said as unconstitutional. But when did this clause H was deleted from the Constitution of India? It is not clearly known. After some time, it disappeared from the 6th schedule again. Then, like there has been certain reservation in ADC. Some laws of parliament and state legislative assembly may not be applicable in autonomous district council area. In this regard, for that, safeguard has been given to Assam in paragraph 12. Then 12A has been added for Meghalaya by amendment of 1969, and 12B has been added for Mizoram by Northeastern Area Reorganization Act 1972. And wherever the word Assam is found in the 6th schedule, it should be replaced by state or by mentioning the state. Then another most important amendment introduced by this act was that classification of the tribal area in paragraph 20. Earlier it was part A and part B. Now by Northeastern Area Reorganization Act 1971 is has to part 1, part 2, and part 3. Part 1 means list of autonomous ADC in Assam, part 2 list of ADC in Meghalaya, then part 3 list of ADC in Mizoram. And the 6th amendment. The 6th amendment is relevant extract of amending, repealing, and amending act. So I've mentioned 3 methods of 6th schedule amendment, and this amendment was only repealing. So by this repeal act of the parliament in 1974, the word cattle ponds in subparagraph 1 of paragraph 6, it was substituted by cattle pounds. That means cattle ponds was, the 2 words cattle ponds were changed by new 2 words cattle pounds. So as I've mentioned, even changing 1 word, parliament amendment is required. So just 1 word has been changed here, but it cannot be done without amendment of the parliament. So for that, parliament amendment is required. That is the 6th amendment. Then the 7th amendment, extension of the 6th schedule in Tripura Tribal Area Autonomous District Council. So tribal areas of Tripura, they repeatedly demanded for autonomous district council under 6th schedule provision. As we know, Tripura is a tribal state, but it is now overpopulated by illegal Bengali immigrants, and tribals who are the native of the lands now constitute only 31% of the population, and they are marginalized now. So tribals repeatedly demanded and fought for security, and Tripura Legislative Assembly passed Tripura Tribal Area Autonomous District Council Act 1979 in the Tripura State Assembly, and after that this was approved by the parliament, and after it was approved by the parliament, it was created under the provision of 7th schedule. It was created under the provision of 7th schedule, and TTADC came into being on January 18, 1982. But as it was under 7th schedule, it did not have the 3 organs of government, legislative, executive, and judiciary. Due to that, the tribal kept on demanding it, and parliament enacted Constitution 49 Amendment Act 1984. So after the amendment of Constitution 49 Amendment Act 1984, TTADC was included in the 6th schedule with effect from 1st April 1985, and after that, TTADC is listed in Part 2A of paragraph 20 of the 6th schedule. So this is 7th amendment, and the 8th amendment may be popularly known to us because in this 8th amendment, the name of Poi has been changed into Lai and Lakher into Mara in 1988. This is Act number 67 of 1988. So as a corrective measure for fulfilling the long cherished dream of Lai tribe and Mara tribe, appellation Poi was changed into Lai and Lakher into Mara by amendment of the 6th schedule in 1988. And in this application has been issued by government of Mizoram on 1st May 1989. And after that, Poi Autonomous District Council was changed into Lai Autonomous District Council LADC, and Lakhal Autonomous District Council was changed into Mara Autonomous District Council MADC. But name of the two tribes are still listed as Poi and Lakhal in tribe recognition list of the government of Mizoram. So this is the 8th amendment. And the 9th amendment was in 1995. So in Karbi Anglong and North Kachar Hills, one new political grouping was formed, Autonomous State Demand Committee, ASDC. And this ASDC demanded for autonomous state under Article 244A of the Constitution of India. In fact, these Karbis and Dimasas, North Kachar Hills, they rejected autonomous state in 1970. So the provision which they rejected in 1970, they began to demand from 1982-83. When I delivered speech in Assam University, Dipu campus 2 years ago on 6th schedule, I mentioned on that day, you Karbi and Dimasa people, the bus which you missed in 1970, you started chasing for it again in 1980s. So how will you be able to reach it? I told them, I mentioned in that my lecture at that time. That's why the provision which they rejected in 1970, they started demanding for it again in 1980, and the demand was so intensive. And at last, tripartite was signed by Government of Assam, Government of India, and ASDC on 1st April 1995. And as per this provision, Parliament has amended schedule, and as a result of this amendment, Karbi Anglong Autonomous District Council was upgraded to Karbi Anglong Autonomous Council, and North Kachar Hills Autonomous District Council was added to North Kachar Hills Autonomous Council. And one new paragraph subclause was inserted in the 6th schedule next to paragraph 3. Paragraph 3A has been added. And in that paragraph 3A, 15 additional subjects are given to autonomous council. So originally, each ADC has around 18 subjects. And in addition to these subjects, the two are now given additional 15 subjects, and they can touch some areas of the 7th schedule. Even in so far as education is concerned, they look after up to higher secondary, but now practically they look after up to college education. In such a way, compared to ADC, this autonomous council now enjoy more than 30 subjects altogether. And this is the 9th amendment. And with this, Karbi Anglong and North Kachar Hills, they were upgraded to the highest status under the 6th schedule. And the 10th and the last amendment up till now is amendment of the 6th schedule in 2003. As we know, in the early 80s, starting from the mid-80s, all Bodo Students' Union up to spearheaded Bodoland movement. And their main demand was divide Assam 50-50. 50 for the Bodos and 50 for the Assamese. Then earlier, they run 24 hours ban, then 30 hours ban. Then after that, they organized 1,000 hours ban. In the initial stage, the ban was peaceful, but after that, it became violent. Then the Bodos took up arms, and administration was paralyzed in Bodo-dominated areas of Lower Assam. Then APSU issued ultimatum to all Bodo youths to leave their college, or government servants also to leave their government job, and all security forces who serve in Assam police or Indian Army to leave their job and fought for Bodoland. And in such a way, even my own Christian College, we had there were 3 Bodo students, but they could not go home. The college sponsored them. In such a way, they faced such harsh problem, and whole Assam was paralyzed. Administration could not go properly, and due to that, tripartite agreement was signed between APSU, Government of India, and Government of Assam in 1993. And as a result of that tripartite agreement, Bodoland Autonomous Council was created. But this Bodoland Autonomous Council was not under 6th schedule provision. Due to that, it did not have much power. So some dissatisfied Bodo youths formed Bodo Liberation Tigers. They took up arms and they continued their movement for Bodoland state. And the movement became so intense. At last, the Bodo Liberation Tigers, Government of India and Government of Assam signed tripartite agreement again in 2003. And as a result of that tripartite agreement, 6th schedule was amended by the parliament in 2003. And this Bodoland Autonomous Council was included under 6th schedule with new name Bodoland Territorial Council, BTC. And it is inserted in paragraph 20 of the 6th schedule. And this Bodoland Territorial Council, for this Bodoland Territorial Council, one new paragraph after paragraph 3A, paragraph 3B has been inserted. And in this paragraph 3B, 38 subjects are included for the Bodoland Territorial Council. And this Bodoland Territorial Council can exercise legislation which are listed, most of the legislation listed in 7th schedule of the Constitution of India. And it has wide fund, and it also has been given many additional funds. For 5 years, during 5 years, every year 100 crores was given to this BTC. And BTC also enjoy many high status. But it is like the power, so to say, it is like state or UT structure. But even this BTC, the funding comes only through the state government. It is not direct funding. Even with regard to North Castle Hills, Karbi Anglong, and BTC, they enjoy most of the subjects in 7th schedule, but they are not direct funding. All their funding comes only through the state government. So this inclusion of BTC, BAC with new name BTC in 6th schedule in 2003, this is the latest amendment of the 6th schedule up till now. So till now, 10 amendments have been enacted. Out of those 10 amendments, 1 amendment was enforced without parliament enactment, and there was some constitutional question which has been solved by the Northeastern Area Reorganization Act 1971. Okay, now we shall deal with amendment. So as there have been constant demand for higher political status, more powers, and more responsibility by ADCs of Northeastern states, the central government kept on inquiring how this amendment would be enacted. That's why the central government, particularly Ministry of Home Affairs, took the initiative to amend the 6th schedule from early 2000. And for this amendment of the 6th schedule, those commissions and research like National Commission to Review the Working of the Constitution, 2001, under P.S. Sangma, the Second Administrative Reform Commission, 2005, under the chairmanship of Veerappa Moily, then Planning for 6th Schedule Areas, 2007, and Core Team to Study on Functioning of Local Government in Northeastern Region with special reference to ADC, 2009, under the chairmanship of Professor David Chimley. So these various teams and research core group, they did research on amendment of the 6th schedule, and those findings of the teams and research coal group have been incorporated proposed amendment by the Ministry of Home Affairs. So one amendment was proposed in earlier known as Constitution 115 Amendment Bill 2011. So this Constitution 100 Amendment Bill 2011 was proposed after incorporating all these suggestions. And one thing that I would like to add is that I was among the 14-member core group team under the chairmanship of Professor David Shimley. And our finding was submitted to Ministry of Home Affairs in June 2009. And in this Constitution 115 Amendment Bill 2011, our finding and finding of some other core teams and research team also have been incorporated, and that has been inherited even by the ongoing Sixth Schedule Amendment. So many findings and suggestions of different research team also have been incorporated even in the ongoing 123 Amendment Bill. And with regard to this Constitution 115 Amendment Bill 2011, the main focus was decentralized village empowerment and to strengthen local government. That was the main focus. But it has been misinterpreted in certain groups as direct funding. It did not mention direct funding at all, but the bill lapsed. The bill lapsed in 2012 and it did not move further. Now, Constitution, we'll move on to Constitution. In fact, this Constitution 115 Amendment Bill was tabled once in the Parliament by the then Finance Minister Pranab Mukherjee, but it lapsed, as I mentioned. And now, Constitution 125th Amendment Bill 2019. This Constitution 125th Amendment Bill 2019, it is not a new development. It is the ongoing Sixth Schedule Amendment which has been initiated by the Government of India and the Parliament since early 2000. And as we know, Sixth Schedule has been amended 10 times in 1954, 57, 69, 1964, 1971, 1974, 1985, 1998, 1999, and 2003. And after 2003, there was no amendment of the Sixth Schedule. And up till now, no new amendment has been introduced after 2003. And what is the real content of this 125th Amendment Bill 2019? So this bill has been interpreted by certain groups as direct funding. But whether direct funding bypassing the state government is in the proposal or not, that we'll look into it. And what is the outcome of this Constitution 125th Amendment Bill? So way back in 2012, Government of India signed Memorandum of Understanding with two underground organizations in Karbi Anglong and North Kachar Hills. United People's Democratic Solidarity, UPDS of Karbi Anglong, and Dima Halam Deoga faction of North Kachar Hills. With these two ground organizations, Government of India signed Memorandum of Settlement. And as part of that Memorandum of Settlement, it was mentioned that North Kachar Hills Autonomous Council and Karbi Anglong Autonomous Council should be upgraded to Autonomous Territorial Council. And in this regard, Sixth Schedule should be amended. So for fulfillment of that, this amendment has been proposed. Then, other than that, this amendment, 125th Amendment Bill, also try to introduce some change in the setup of commission. The setup of Finance Commission, that Finance Commission should demarcate some funds clearly for ADC so that this funding of the ADC cannot be diverted by the state government. That is also one of the purpose. And the bill contains many provisions, but we may not be able to touch all the provisions. We'll briefly highlight some of the content of the bill. First, State Finance Commission. So in this, Article 280 should be amended. And in this Article 280, like Article 280 should not mention distribution of taxes between union and states, but provisions should be laid down so that grant in aid and additional fund should also be properly handed over and properly channelized to local bodies like district council, village council, and municipality. Then in paragraph 280, one new clause should be inserted. And by new clause, State Finance Commission should be set up. Instead, where there are ADC. And that State Finance Commission should demarcate the funds which would go to local bodies like ADC, municipal corporation, village council, local council, and all. So it suggested for creation of state finance so that there should be proper flow of fund to ADC and other local body. Then point number 2, autonomous territorial council. The bill also proposed that 2 autonomous district council of Assam, 2 autonomous council of Assam, 3 ADCs of Meghalaya, and the TTADC of Tripura shall be autonomous territorial council. But here in the bill, it is not recommended for Mizoram because in Mizoram, ADCs are located only within one revenue district, but in rest of the state, in one ADC, for example, in TTADC, there are almost 8 revenue districts. Then in Khasi also, there are about 4 revenue districts. In Garo also, there are about 5 revenue districts. Then in Zentia, there are 2 revenue districts. In such a way, the bill mentioned that it is not feasible for Mizoram. But this is just a proposal. If the parliament changes it, then territorial council also may be possible for Mizoram. Depends upon the decision of the parliament. This is just the proposal. Then restriction of membership in legislature. So earlier, member MDC, they had the facility for double membership. MDC can also be MLA, MDC can also be member of parliament. But these provisions should be put to an end by inserting sub-paragraph 7 in paragraph 2. And it is mentioned that with the declaration of elected list of member of parliament in the Gazette of India and member of legislative assembly in the Gazette of the state within 14 days, if such MDC are elected as MP and MLA, their membership in the district council should be put to an end within 14 days. Then, so in such a way, double membership is restricted now. Then State Election Commission. So after paragraph 2, sub-paragraph 7, sub-paragraph 8 shall be inserted, and their State Election Commission shall be inserted. Up till now, State Election Commission has already taken over election in Mizoram also, but it is not properly inserted in the 6th schedule. That's why this is a proposal for proper insertion of the rest of all election 6th schedule area. Then next, village council and municipal council. After paragraph 2, paragraph 2A shall be inserted in the 6th schedule to the Constitution of India. That means within 1 year of the enforcement of this Constitution 125th Amendment Bill, each ADC should pass legislation by which those ADC which do not have a village council yet, they should create village council, and those ADC which do not have a municipality, they should pass legislation within 1 year of the enforcement of this 125th Amendment Bill, then municipality should be created. Then this legislation should be assented by governor of the state, and after it has been assented by governor of the state, then it should be published in the Gazette of the state. Then devolution of power to local bodies. The bill also states that governor may make rules, devolution of powers and responsibility to village council and municipal council. That means when municipal councils and village councils are created, governor of the state should take to such municipality and village council. Then insertion of new words in paragraph 3, subparagraph 3A. So then one new paragraph 8A shall be inserted, where the responsibility of the finance commission should be, state finance commission should be mentioned. That means state finance commission should be appointed by the state government, and that state finance commission should be responsible for allocation of funds to ADC and other local bodies like municipal council, local council, and village council. Then provision for disqualification of MDC should also be inserted in paragraph 2. And so those are the rough, just to state the bird's eye view main content of the bill. Then in pursuance of Rule 270 of the Rules, Procedure and Conduct of Business in the Council of State, Venkat Naidu, Vice President of India and Chairman of the Rajya Sabha, constituted departmental related parliamentary standing committee to study about the proposal of this 125th Amendment Bill 2019 under the chairmanship of senior MP Anand Sharma. And this committee comprised of 49 members. Out of these 49 members, 10 are Rajya Sabha MPs, then 31 are Lok Sabha MP, and 7 members are government officials. And the committee was entrusted to look into the matter and report to the submit report to chairman of the Rajya Sabha. But the committee could not take up because of the Lok Sabha election. Then term of the committee was extended by the chairman, and then the committee took up the initiative. The committee visited northeastern part of the country. They went to Shillong and Guwahati from 18 to 21st January 2020. Then in the meeting held at Shillong on 18 January 2020, committee heard the view of different tribal organizations and stakeholders of the Chief Secretary of the state government, and they met the Chief Secretary of Meghalaya, Mizoram, Tripura, and Assam, and they also met leaders of ADC. They also met different tribal organizations. Then the committee had intensified studies. Then after that, the committee had 4 seats. Then after taking all those pros and cons into account, after meeting tribal representatives, the state government, different tribal organizations, the ADC leaders, then the committee prepared its report, which was publicized by the chairman Anand Sharma on 4th March 2020. And some of the recommendations of the committee with regard to specific Mizoram ADC shall be briefly highlighted. So the committee felt that steps should be taken up for creation of State Finance Commission. Then the committee also felt that as this 3 ADC of Mizoram are located within one revenue district or 2 ADC in one revenue district, it may not be feasible to name the ADC as Autonomous Territorial Council. But as I've said, this is the view of the committee. If the parliament changes it, it can be Autonomous Territorial Council also. This is just proposal. So it depends upon the view of the parliament. And state government of Mizoram also proposed to transfer some technical education up to higher secondary to ADC. Then one new paragraph 3C shall be added for the 3 ADC of Mizoram. Then the committee also felt that Ministry of Home Affairs should discuss with the state government about devolution of powers to the 3 ADCs of Mizoram. And some of the suggestions generally for the ADC, Autonomous Council and Territorial Council of the Northeast shall be highlighted as given below. And the committee, Anand Sharma committee, felt that appropriate steps should be taken by its council so that appropriate local government, village council and municipality be established in its ADC area. Then provisions enumerated in 11 and 12 schedule for Panchayati Raj and for municipality shall also be incorporated in the 6th schedule in clause 3A2 of the 6th schedule. Then the committee also felt that this provision of 11th schedule and 12th schedule should be incorporated and should be properly implemented in the 6th schedule. Then the committee also felt that the purpose of this 6th schedule amendment is to bring ADC at par with other local bodies of the country. So in this regard, appropriate steps should be taken so that State Finance Commission and State Election Commission should function properly, which should enable and strengthen local self-government, local government. And the committee is also aware of shortage of fund in ADC. Due to that, the State Finance Commission should be created, and this State Finance Commission should earmark the funds which are required by ADC, so those funds may not be diverted by the state government. And the committee also noted the view of Ministry of Affairs that the term Territorial Council should be used for ADC which cover more than one revenue district. And the committee also felt that agreement and approval of the state government, the respective state government may be required for enactment and enforcement of this legislation. And power devolution should be taken into account. And the committee also felt that direct funding of ADC by the center will not only be against the existing institutional scheme, but would unnecessarily affect relation of ADC with the state government. That's why this Article 280 should be amended. Then State Finance Commission should be created, and it will be like the same provision in 73rd and 74th Amendment. In such a way, great role should be given to this State Finance Commission. And the committee also felt that earlier there was no disqualification for member of district council. Therefore, these provisions should be inserted in subparagraph D of paragraph 6. And Ministry of Home Affairs has stated that proposed amendments have been made to bring in elements of Panchayati Raj institution in the 6th schedule area. And the ministry felt that this will strengthen democracy at village level, both in urban and rural area, and it will also devolve power, and fund will go to the ADC. I mean, fund will go to local body, whether it be village council or municipality, and that will benefit the people, and it will also develop the area. That's why the main focus of the amendment, as I've said, mentioned earlier, it is decentralization. Decentralization, power to the local people, and to strengthen village administration and urban local administration. That's why the committee felt that the creation of the State Finance Commission may solve certain funding problems of the ADC. Okay, I will now come to the concluding remark. The provision of the 6th schedule to the Constitution of India is a unique feature for preservation, protection, and promotion of the land, ethnic identity, custom, culture, and tradition of the Hill tribe. The 6th schedule has been amended 10 times up till now. An amendment in 2003 was the latest amendment up till now. There has been preparation for amendment of the 6th schedule since 2000, and different study research teams have also been engaged by the central government, and research findings of the different study teams and research teams have been incorporated in the ongoing amendment process. The proposed 6th schedule amendment has been misinterpreted as direct funding by certain group. Constitution 115 Amendment Bill lapsed, and after that, Constitution 125th Amendment Bill 2019 is still in the process, and its focus is mainly on democratic decentralization, giving more powers to ADC, but direct funding of ADC by the central government bypassing the state government is not found in the proposed provision. But as I've mentioned, final authority lies with the parliament. If the parliament enact and change it, there may be possibility of direct funding. If not, so far as the provision is concerned now, it is not found in the provision. Therefore, any political propaganda or political slogans should be carefully assessed in order that practical and realistic approach can be adopted for development of the people of the area. As we are now in the 21st century, where media is so strong now, because authenticity of any political slogan or propaganda will be always highlighted in media by aware citizens. Over and above that, public, particularly, will no longer blindly believe whatever political slogan which has been publicized, like what was done in the 80s and 90s. Due to that, military junta in Myanmar too can no longer dictate its terms like what it did in the 60s and 80s, because the media is so strong now. Therefore, propagation and publicization of political slogan, which is far from reality, may only be suicidal political gain for those who propagated the slogan. It can be expected that 125th Amendment Bill may be passed by the Parliament sooner or later, and it is likely to give more power, more funds, more subjects, and more responsibility to the ADC. But whatever amendment it will be, the ADC fund may continue to flow from the central government only through the state government. But if the Parliament changes the proposal and Parliament enact the bill for direct flow of fund bypassing the state government, there may be possibility. So we have to wait and watch how the 125th Amendment Bill is enacted by the Parliament. Thank you all for your patience. Now the time is handed over to Zari.
Okay, sir, thank you so much. Your presentation was so insightful. It is thought-provoking and informative as well, dealing with the precisely with the historical background first, and then incorporation of the sixth schedule to the Constitution of India, and also touching upon the subsequent amendment of the sixth schedule. Moreover, thank you for the clear explanation of the direct funding. And sir, you're so well versed with all this chronological year, and for that I have to congratulate you. And I have received a number of interesting queries. Let me read out the first question. The question goes like this: is direct funding possible by amendment of the sixth schedule? Sir?
Yeah, in regard to that, up till now, it is not in the constitutional provision. If the parliament amend it, it is possible. It is with the parliament. We cannot say it is possible or impossible. If the parliament enact it, it is possible. It depends upon the will of the parliament. I cannot say that.
Okay,
It
thank you,
depends
sir.
upon the decision of the parliament.
And the next question goes like this: what do you think is better for Mizoram, the sixth schedule to the Constitution of India, or the 11th or the 12th schedule?
No, as per the proposed amendment, for example, in Mizoram, what we have followed now, it is combination of 6th schedule, 11th schedule, and 12th schedule. And as member of Mizoram Local Government Panchayati Raj Committee, we are continuously working on introduction of certain provision of these 11th schedule in the village council structure. We are still working on it, and it is not yet finalized. That's why it is in the process. And on the other hand, this Aizawl Municipal Corporation, it is based on the 12th schedule. And due to that, even this 11th schedule and 12th schedule, certain form of 11th schedule and 12th schedule, it is also in the process. And so far as this 6th schedule area is concerned, it is a bit different. The thing is that I have mentioned in my lecture also, now there is proposal for insertion of this 11th schedule and 12th schedule in this 125th amendment bill. That means those local government in the village area, particularly village council, in this village council, at least certain form of these 11th schedule should be inserted. Then in the town area, in municipality, these 12th schedule should be inserted. So the process is on. That's why Ministry of Home Affairs, that I have mentioned also, Ministry of Home Affairs also gives so much importance to insertion of these two very schedules, 11th schedule and 12th schedule in the 6th schedule, so that power will not be centralized in the district council headquarters at Long Klai, Chongte, or Saiha. It may reach Tuipang, it may reach Watwampui, it may reach Borapunsura, it may reach Vasaikai. That is the main proposal. On the other hand, we can mention that even if there is a little bit of corruption, corruption will be decentralized. It will reach the local people in such a way. So the main aim of this 125th amendment bill is decentralization, insertion of these 11th schedule and 12th schedule in the ongoing 6th schedule amendment proposal.
Okay, thank you, sir. Another question: is there any other option other than the direct funding?
Yeah, the amendment bill is still working on it. And as I've said, if the proposed 125th amendment bill is enacted, ADC will be in better status. Like the funds and other facilities of the ADC may not be diverted like before by the state government, because if there is proper state finance commission will demarcate the funding properly, so that funds of ADC may, and it may no longer be disturbed. Due to that, this proposal is there for establishment of State Finance Commission, and through the State Finance Commission, the funding of the ADC and other local bodies will be channelized and will flow properly. Due to that, that is being worked out and that is being processed by the 125th Amendment Bill.
Okay. Sir,
And
the
with
next
regard
question-
to that, let me add just one sentence. With regard to that, this direct funding may not be totally impossible. If the parliament amend it, it is possible. That's why I cannot say it is possible or impossible, but it depends upon the will of the parliament. If the parliament amend it, parliament can do anything. Even if it is not in the constitution, if the parliament wills, the parliament can do it. So it is the decision of the parliament. But will decision of the parliament go against the proposer? That is the question.
Okay, thank you, sir. Another question. Since direct funding has become an election propaganda, how far do you think can this continue?
Till this 125th Amendment Bill is enacted by the Parliament, it comes out in the Gazette of India and it is publicized with the knowledge of the public. I think this slogan will go on. Let the bill be first enacted by the Parliament. Then after that, I think everything will be clear.
Okay, sir. And I have received a number of questions. Another question goes like this. What is the biggest constitutional legal constraint against direct funding at present?
No, like as I've said, up till now, there is provision for direct funding only for state and union territory. I've mentioned that Bodoland Territorial Council, it is like a state structure. It controls up to college education. Then with regard to status also, Chief Executive Member and Chairman of Bodoland Territorial Council, Kalbi Anglong Autonomous Council, and North Kasar Hills Autonomous Council, they are equivalent in rank to Cabinet Minister of Government of Assam. And sometimes they can even attend cabinet meeting. They are respected in status of government in precedence and protocol of the government of Assam and Tripura also, even in Tripura also. But even their funding goes only through the state government because provision is there in Article 2751 of the Constitution of India. So, as I've said, it may not be totally impossible because Parliament can do anything. If Parliament amend 2751, that if there is change in the wording in 2751 that District Council may receive Consolidated Fund of India directly from the center, then it is possible. So it is the will of the Parliament. If the Parliament does it, it is possible. But having said that, the thing which I would like to add is that in TTADC Tripura, BTC Assam, Kalbi Anglong and North Kasar Hills, their CEM and chairman, they are equivalent to the rank of Cabinet Minister of the state. So right now, Meghalaya and Mizoram, with regard to precedence and protocol, Mizoram and ADC of Mizoram and Meghalaya, they are in the worst situation. Like in Mizoram and Meghalaya, CEM and chairman, they are in equivalent with Deputy Commissioner of District, some secretary. That is too much. In fact, they should fight for their status in precedence and protocol. Actually, CEM and chairman of ADC should be in the rank of cabinet minister or at least minister of state. So that's why their status also should improve. As I've mentioned, these BTC, Kalbi Anglong, then TTADC and all, they are CM and chairman, they are equivalent to rank of cabinet minister, and they enjoy even 7th schedule and most of the power of the state government, but their funding is not direct. It is only through the state government. That's why possibility of direct funding is amendment of Article 2751 of the Constitution. It is not totally impossible. It depends upon the decision of the Parliament.
Okay, sir. Another question. Sir, what more instruments do you think can be added to our ADC's model vis-a-vis the American native governance model?
There is also decision of the Parliament. In America, the situation is different. And right now in America, there are 574 federally recognized tribes, then 20 state recognized tribes, and about 200 tribes were already de-recognized. Then out of those tribes, there are 159 tribal nation governments. And the situation in America is that these tribal nation governments and reservations have been established on the basis of treaties signed by federal government and different tribes. So federal government of United States signed more than about 390 treaties with different tribes. And on the basis of those treaties, these tribal governments and reservation function. It is much constitutional. But as you know, American Constitution is not detailed constitution. That's why detailed provision of this functioning of tribal nation government are not given in the Constitution. But these tribal nation government, they have their own constitution. Their powers and responsibility depends upon how they drafted their constitution. Each tribe, they prepare their own constitution, and that has been enforced with the permission of the federal government. So all their powers and responsibility depends upon the constitutional provision. And as I've mentioned, these tribal nation government, they have their own constitution, they have their own flag, and they have their own citizenship. And state government is not involved at all from the very beginning. If there is involvement of the state government, then warning will be given by Supreme Court of the United States of America. In such a way, the background, the setup, and the structure is different. Due to that, ADC under 6th schedule in India and United States cannot be compared because the background is different.
Okay, another question. I think this is the last question. If 6th schedule amendment is implemented, do you think dual system, that is Council and State Department of Administration within ADC area, will merge into one?
That is already functioning in Karbi Anglong and North Kachar Hills. In Karbi Anglong and North Kachar Hills, most of the state governments which are in the area also, it is now being controlled by the territorial council, even recruitment also. But I don't know what will be the situation in Mizoram. It depends upon the decision of the state government also. If the state government refuses to hand it over, union government may not be able to force it. That's why consent of the state government is also required. With the case of Karbi Anglong and North Kachar Hills, the state government willingly hand over their powers and responsibility to the Autonomous Council. But will the state government of Mizoram do it for the ADC in Mizoram? Due to that, when I pointed out the view of the Home Ministry also, the view of the committee, in one comment of the committee, it is mentioned that the Home Ministry shall discuss with the state government for devolution of power to the ADC. So in this regard, the willingness, cooperation, and participation of the state government is also very important.
Okay, sir. Another more questions. As much as direct funding is desirable, do you think there is enough accountability and transparency among ADCs in Mizoram? Recent CAG reports often found certain issues in handling of accounts. Do you think we need to work on the accountability part as well?
I think the answer is already known to the public. I may not further speak on it. We all know what is going on. So it is open to all of us. And I feel that I need not speak further in that regard.
Okay, sir. We'll take one more question, last question. What about 33 reservation for women in ADC?
Yeah, in the amendment process, in 125th amendment process, it is not directly mentioned. But this women reservation has been championed and women reservation has been advocated. So up till now, it is not there in the proposal. And with regard to this, it cannot be implemented even in Parliament and State Legislative Assembly up till now. If it is not implemented in Parliament and State Legislative Assembly, I am doubtful for its implementation in the 6th schedule. Because with regard to this 1/3 reservation, I think it is lip service of many political parties, but from their inner hearts, I doubt whether the political parties are really supporting it or not. That's why it is ongoing development.
Okay, thank you, Professor Dongle, for attempting all the queries satisfactorily. I am very confident that all the participants will be benefiting through your deliberations. Now, let me hand over the time to our chairman. Sir David, over to you.
Thank you. Thank you, Mrs. Sar. Thank you for moderating the session smoothly. And I thank the resource person for a very detailed, insightful, a bold explanation and a very highly informative presentation. It was well expected, and thank you so much, Professor Dongle. And I hope the listeners, the participants, will have a rich experience through the explanation and insightful experience through his presentation. And I hope we all benefit from what he said and the information that we gained through his presentation. It was very fruitful. And now there's a few announcements. I will ask one of the organizing secretary, Dr. Mama, Dr. Lalun Kima, to please do the needful.
A small announcement regarding e-certificate. For those who have done registration through Google Form for this international webinar, feedback form will be sent to your respective email. And I request every one of you to kindly write your feedback or remarks and send back to us. Your valuable feedback will be highly cherished and will help us in our upcoming webinar as well. And also e-certificate will be distributed only to whom feedback has been received. And again, to those of you who have attended our webinar without doing registration, may contact the organizers for e-certificate. Organizers' contact will be dropped in the chat box after this session. Thank you.
Okay, thank you, Sir Mama. Well, I would like to acknowledge some of the participants. Like the resource person has acknowledged that our former principal, Puti Thangtruma, is a former principal of Long Klai College. He is here with us. And also our former professor, Professor Vanalving Aboitlung is here with us. We thank you. And I see that Prof. Julian Zuala our Joint Director, IQSC in charge. We thank you so much for your presence. And I thank all the participants. I now hand over the stage to Ms. Ruth, the HOD English Department, to propose a vote of thanks.
Thank you, Sir David. As we have come towards the end of our international webinar on amendment of the 6th schedule to the Constitution of India, there are several people who would like to thank for their valuable work and service for the success of this webinar. First of all, I would like to thank our resource person, Professor J. Daungal, who can be with us to share his great intellect all the way from the other end of the world. We are very happy that he accepted our humble invitation to be our resource person in spite of his busy schedule. We know that there are no other person who is more expert than you in this topic, sir. We are very lucky to have you as a resource person, and we greatly appreciate your effort. Thank you, sir, for your insightful and informative lecture, and we wish you all the best for your future endeavor. I would also like to thank our principal and vice principal, Mr. J.S. Fanchun and Mr. L.H. Moyah for their wonderful support and guidance. And I would like to thank all the participants. We know that we have participants from outside Mizoram, like from places like Manipur, Assam, Itanagar, and even from outside India, and many from Mizoram. We thank each and every one of you for your participation. It is all because of you that this webinar can become a success. I would like to give a special thanks to Mr. Lian Zwala, our Joint Director, for gracing us with your presence. And also a special thanks goes to our former principal, Mr. Thang Chuama, and Professor Ring Thea, our former colleague, for gracing us with their presence. It's good to see your faces. Our heartfelt thanks goes to our two organizing secretaries, Dr. El Izami and Dr. El Nunkima. We know you both have worked really hard in spite of all your busy schedule to make this webinar a success. We really appreciate your hard work. Thank you, Dr. Mazami and Dr. Mama. The next person I would like to thank is Dr. David B. Kyangte, our IQSC coordinator. We really appreciate you, your hard work and your dedication. And our thank also goes to Ms. Zari, Ms. Sangliani, and their contribution and hard work to make this webinar a success. I also thank Mr. Rempuya Rokum for allowing us to use his YouTube channel so that more participants can join the webinar. And last but not the least, we give thanks to our Almighty God. It is only because of his wonderful grace and guidance that we are here tonight doing what we have to do. And with that, I'll end my time here. Thank you, everyone, and good night.
Okay, I'll just, before we end the meeting, we'll have a group photo through this Zoom. I will request all of you to put on your cameras so that we can have a click.
Why Puringte is lost?
Yeah, Puringte, yes, Puringte.
And our principals are also.
Yes,
Let's put on
How is it?
the camera, please.
it's all right.
Okay. Ready? Okay. Let's put on. I think some of you haven't put on. And click through. Most of you are not putting on your camera. Please, I request all of you, those who have not put on their cameras. Okay. Okay, thank you, everyone. We can have a short chat if anyone is willing to. Professor Ringtea, Thang Chuama, please stay back. Don't quit. anyone interested to have a small chat, you're welcome.
Di tina hun kan mangang so.
Thank you, everyone. Thank you for joining us. Hope to
Thank
see you again.
you.
I leave the law for ring teacher.
Leave
No,
Lu,
no,
hello.
no, no.
Yes.
I'm with you.
If anyone is willing to have a small chat, let's have. Dr. BD Adong is there. Thank you. Thank you, Doctor.
Yeah.
Thank
It's
you
good
for
that
giving
Dr.
me opportunity.
Welcome.
Especially thanks to Professor J. Dongle sir. It was excellent presentation with informative knowledge and full of informative lecture session we had with him. And happy to see him. He's from long way from abroad, connecting with us. Actually,
He is still free from COVID, so it's it's a happy good news.
yeah. So nice to meet you all and hearing sir once again. Thank you. It was excellent, excellent presentation from Professor Dongle sir, and thank you all.
Yeah. Dr. BD Adong, he is assistant professor in MDV University,
Political
the newly
science
created
syllabus
university in Agartala. Earlier, MDB College. So it is one of the emerging and good university.
Hello, I'm here, sa
Thank.
former principal putting that one on alone.
Hello.
Then principal,
Hi,
putting
yeah,
that
so
on
xin
the
phép mẹ
table,
lộn. Thank you all for organizing a very successful seminar.